Hello, welcome to another edition of the Layman Law Series. Like I said, law is actually a very boring subject, so please, we'll try to make it as interesting as possible. Okay, now today we'll be talking about classification of contracts. The first classification of contracts is into contract under sale and simple contracts. Now, contract under sale are contracts that are written, properly documented, and they are signed, sealed, and delivered by the parties. This is simple. When you put everything you've agreed between your other party, you put it in a single document. It is typed and written, and you can see it in black and white. Then each party executes and signs his signature on top of it, appends his seal, and it is delivered. That is what a contract under sale means. Okay, now any other contract apart from a contract under sale is a simple contract. So you have contracts that probably are partly written and they might not be executed, or they are probably in any other form. Maybe they are in oral form, they are oral contracts. So so those are simple contracts. The law recognizes them as simple contracts. Okay, we also have another classification, which is the express and implied contracts. Now, of course, like the name implies, express contracts are contracts that the terms are already clearly stated in the contract document, so it's easy. Nobody needs to fight about it because you wrote everything that you agreed on in a single document and you signed. Okay, now implied contracts, on the other hand, are contracts that probably they might not be written, but the law would imply that there is a contract between parties from the conduct of parties. Okay, so sometimes the contract can be written, but they might not even be signed. So in that case, it doesn't mean that there's no contract. There is actually contract, because the law will look at the fact that parties have come together, or parties are in the mode of doing something in a particular way before, and it is in form of performing the contract that was not signed. That way it will be called an implied contract and the law will still enforce it. Okay, so we're going to go over now to bilateral contracts and unilateral contracts. Bilateral contracts are contracts between two or more people. So party A makes promise to party B in an exchange for promise from party B to party A. So that's a bilateral contract simply. At that stage, consideration has not passed. It's just agreeing, just promises that have been exchanged. There's no performance of the consideration yet. So that's an executory consideration. It has not been executed. Okay. Now, on the other hand, a unilateral contract is a contract between one person and the whole world. Right? Okay. How does this sound? One person cannot make a contract to the whole world. I know you're thinking about it. Okay. So I know you probably heard of a jingle by all these companies where they say, oh, gather like 50 wraps of our product and come to a redemption center to win something, right? Okay, so that is an example of a unilateral contract. So you make a contract between you and a whole world. So any person who performs the consideration which you said, to gather wraps of particular product or to do this particular thing, anybody who does that and comes to you has performed the contract. So the law stops the person or the company from going back to say, oh, we did not say this, or you did not tell us when you were doing it, or this. All that is not necessary. The law recognizes such contracts as unilateral contracts. So we hope that you've learned one or two things from this video, at least on classification of contracts. So like and follow us on all our social media platforms, and subscribe to our YouTube channel, try to encourage us to continue to do more videos to educate you. Thank you very much.